A jury finding Charleston church shooter Dylann Roof guilty on all 33 counts this week, including charges of murder and hate crimes. Jurors soon deciding whether he will spend life in prison or be sentenced to death for the murder of 9 black parishioners inside a historic church. The killer telling a judge he wants to represent himself during the punishment phase. Joining me now is David Schwartz, a defense attorney and former prosecutor, and Doug Burns, also a defense attorney and former federal prosecutor. Doug, I'll start with you. Sure. So if he represents himself, could he end up addressing the victims' families in court? And if so, is there anything that he might say that would be, I don't know, considered in contempt of court, where they just shut him down?
You know, the pro se landscape is tough. You know, pro se meaning a person represents themselves. I did 2 trials as a federal prosecutor against defendants who represented themselves, but they were in federal tax cases, not violent crime cases. But to answer your question, the point is that for him to represent himself in the actual penalty phase, whether he's going to get the death penalty or not, you know, is a terrible, terrible idea, and could backfire pretty badly. I just don't think that's smart.
Does this suggest that he wants the death penalty? I mean, is he a guaranteed candidate for death row, David?
If there's ever a candidate for the death penalty, it's this particular defendant. I think a lot of people could agree with that. But however, you know, who knows what's in his mindset? I think this actually goes towards one of his most mitigating circumstances, because we weigh the aggravating factors versus the mitigating factors, and his mental condition, and it doesn't rise to the level of insanity like it would in a trial as an affirmative defense. This is just his mental condition impairing his judgment to such a point where he would get life instead of a death penalty.
He wrote a letter to the judge, Arthel. This is unbelievable, and it really tracks right into your first question, which is, what is this guy doing and what is he thinking? He wrote a letter to the judge saying he's not going to raise any of these mental issues. Those are the identical issues that a lawyer would raise, which is not insanity at the time of the offense necessarily, but his mental state overall as a mitigator why he should not receive the death penalty.
David, is there any way that he could appeal the decision, whatever it is, and maybe even come back with lawyers to help him appeal it?
And that's going to be probably the #1 appealable issue, is his right to counsel. Even though he's waived his right to counsel, based on the severity of this case, certainly that'll be a major appealable issue. He won't only have one appeal. He's going to have many, many appeals, many motions for a new trial, if he does end up getting counsel. And certainly on the appellate level, he'll have counsel.
But 2 things on this going pro se point. #1, the judge puts you through a very rigorous colloquy, to make sure it's voluntary and so on. #2, they actually appoint an advisor, a lawyer, to sit there. And if that happens, I've seen this play out a number of times in cases, then that diffuses the idea, I really did want a lawyer. I said, well, we gave you one. And he was sitting right there.
So I mean, you look, so this guy is sane enough to know that he's actually working his way through the system right now.
Yeah, he's sane. I think that the crime itself was thought out. He plotted it out. He sat there. I think we know the painstaking facts of this case. So certainly the mental portion of this crime, certainly the intent was there more than ever. So, but in the penalty phase, again, it's a different standard completely when it comes to mental illness.
And also in death penalty cases, it's entirely legitimate for people to be very upset with the concept of the death penalty when you have like identification cases, scientific identification. But in this case, there's no dispute whatsoever as to who did this crime.
Lastly, how long could this drag out?
Years and years. It could, I mean, we've seen death penalty. Let's say he does get the death penalty. It could drag out
10,
for 20 years,
yeah.
15 years, 10 years.
David Schwartz, Doug Burns, I leave it there. Thank you very much, and we would like to remember those who were killed at Mother Emanuel AME Church. Reverend Clementa Pinkney, 41 years old, the senior pastor at the church. Sharonda Coleman Singleton, 45, an assistant pastor at Mother Emanuel. Tawanza Sanders, 26, he was a 2014 graduate of Allen University. Ethel Lance, 70, worked for 30 years at Mother Emanuel. Susie Jackson, 87, a longtime Emanuel AME church member, also the cousin of Lance. Cynthia Hurd, 54 years old, worked as a regional branch manager from the Charleston County Public Library System. Myra Thompson, 59, the wife of a pastor. She had 2 children of her own, as well as a stepchild. Reverend Daniel Simmons Sr., 74, a retired pastor from another church in Charleston. DePayne Middleton, doctor, 49 years old, a retired government employee. And, you know, as Christmas Eve is 1 week away, we would like to wish the families of the victims comfort and peace.